The United States Supreme Court recently issued a decision which may have an impact on workers' right to strike. The case was called Glacier Northwest, where the Supreme Court ruled that an employer could proceed to sue a union in state court for alleged harm to its product caused by the strike. In that case, the employer claimed that the union intentionally timed the beginning of the strike so as to increase the chance that the employer's product would be damaged. Unions are concerned that this decision may encourage employers to bring more such lawsuits, thereby undermining the right to strike. As a practical matter, we don't believe that the decision will have a significant impact on the IAM. That's because our members don't usually handle perishable type products. In Glacier Northwest, the product was concrete, which is at risk of hardening, and because it is unusual for IAM members to fail to shut down equipment or otherwise take appropriate steps to prevent damage to an employer's property before commencing a walkout. Nevertheless, there are steps that should be taken before the beginning of a strike to reduce the odds of facing such a lawsuit. First, consider whether the strike could cause harm to the employer's equipment or product. This is different than the question of whether the strike may cause harm to the employer by shutting down the operation and preventing production. This type of quote-unquote harm is legally protected as part of the right to strike. Second, consider whether to give express notice to the employer that the strike is going to start, such as a message stating, as you know, the union intends to commence a strike anytime after 12:01 a.m. on December 1st, particularly when it is not already clear that the union intends to begin the strike as soon as the contract expires. Third, if the stoppage might foreseeably cause damage to the employer's equipment or products, make sure that workers take proper precautions, such as shutting down machinery before walking off the job. Fourth, make sure to file unfair labor practice charges for any unlawful employer conduct, such as unlawful surveillance or discipline of strikers. This is important because ULP cases are decided by the National Labor Relations Board, and if the NLRB determines that the strike is lawful, no damage action can be brought in state court. And fifth, if the employer does bring a lawsuit for damages, we here at the IAM Legal Department should be notified immediately. There are steps we can take, such as asking the state court to put the lawsuit on hold pending the resolution of ULP charges. But to do so, we need to get involved right away. In conclusion, while this decision by the Supreme Court, which is increasingly hostile to workers and their unions, is a cause for concern, it's not the end of the road for workers' rights. We must remain vigilant, continue to fight for fair labor practices, and protect the rights of all workers, even in the face of challenging legal decisions. Thank you for your attention, and let's stand together in our commitment to the rights and well-being of our members. Thank you.